This is the story of a man standing on a razor's edge. George Hawkins III walks into court with a plea deal that could keep him out of prison, facing a judge who has the power to send him away for 2 decades. He spins a tragic tale of success, sobriety, and a single devastating relapse that he claims unfairly derailed his life. He presents himself as a victim, misunderstood by a system he was trying so hard to conquer, but this judge isn't just any judge. She has years of first-hand experience with the very drug court program he's talking about, and his story isn't adding up. What starts as a simple hearing quickly transforms into a tense, high-stakes investigation as the judge decides to fact-check his story in real time. One email is about to change everything, exposing a web of deception and revealing the one crucial detail the defendant conveniently left out.
So here's the thing. Now you're changing you're moving the goalposts. At first you're like, no, I never did it. I never turned down residential treatment. No residential treatment was never offered to me. And now we're on this kick where now you're saying, well, I don't understand all this legal things that are going on. The legal things that's going on when a judge tells you absconded from the sober living house, you've relapsed, we're going to try to get you back in compliance by you're going to a residential treatment, and then you say, no, you're not following that plan. So, counsel, here's the court's issue. Felony drug court wanted him in inpatient treatment. He said no. There is nothing I can do for him. 390, State versus George Hawkins III. Could I have parties announced?
Andrew Harrison, State.
Brent Hardy for the defendant.
Are you Mr. Hawkins?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same George Leverne Hawkins III who was placed on deferred adjudication in 2024 CR 5390 for the offense of assault on a peace officer or judge on August 8, 2024 for a period of 8 years? Is that you?
Yes.
All right, State, you may proceed.
On or about the 30th day, April 2025, in Dare County, Texas, the defendant George Leverne Hawkins III committed the offense of criminal trespass and violation.
How do you plead to that? True or not true?
Sure. State waives the remaining violation allegation.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Judge. Deny the motion, alternative.
Let's break down what's happening here. The defendant, Mr. Hawkins, is on deferred adjudication. Think of it as a contract with the court. He pleaded to the original offense, assault on a peace officer, but the judge held off on finding him guilty. As long as he follows all the rules of his probation, the charge can eventually be dismissed. But if he violates the terms, as he's accused of doing with a new criminal trespass charge, the judge can revoke the deal, find him guilty, and sentence him to the full range of punishment, which in this case is a staggering 20 years in prison. The state has offered an agreement to keep him out of prison, but the judge doesn't have to follow it. Right now, Mr. Hawkins is testifying to convince her that he's worth a second chance, painting a picture of a model participant in drug court who just had one slip-up.
State will take into consideration dismissive the new offense, although we request the no contact order with Cross Towers located at 111 West Houston Street.
And what is the cause number?
2025.
The judge's skepticism is palpable, and for good reason. She isn't just presiding over this case, she's an expert on the very program Mr. Hawkins came from. She explicitly states she was a defense attorney in that specific felony drug court for years. This is a massive problem for the defendant. He's trying to sell a narrative that the program is harsh and unreasonable, kicking people out for a simple relapse. But the judge knows firsthand that's not how it works. She knows they go to extreme lengths to help participants, expecting and managing relapses as part of the recovery process. Her probing questions aren't just curiosity, they're a targeted challenge. She senses a massive piece of the story is missing, and she's not going to approve any deal until she finds out what really happened to get him kicked out of the program.
CC 006392.
All right, counsel, is that the agreement?
It is, Judge.
All right, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
George Leverne Hawkins III.
All right, so why were you at Frost?
Well, it began whenever I relapsed. I was a year sober on methamphetamines.
Mhm.
I was in drug court. I actually wrote a letter to explain it all to you.
Mhm.
You would like to see that, but I could explain it in words.
Sure.
So, I was actually doing really good in drug court, and it kind of took me by shock whenever the district attorney in drug court, put in the motion to revoke, because I had been a year sober. I had been going to all the meetings. I was in Rosetta Keys, going to groups 2 times a week, and also the individual sessions with Tammy Banfield, and also I was seeing the judge during his sessions each month, and I was also seeing Elsa Guajardo
All
over
right,
at.
so there has to be more going on, because felony drug court would not put you out of their program just because you started using again. So there's something, what else is going on?
I did make a few slight mistakes whenever I was.
This is the moment the entire case pivots. The defendant has given his full polished story. He claims he was doing great, that his relapse was an isolated incident, and that he was baffled by his removal from drug court. But the judge remains unconvinced. Instead of taking his word for it, she does something brilliant. She puts the hearing on pause to get the truth directly from the source. By asking Ms. Abrams to email the felony drug court program manager, she's essentially launching a real-time investigation. The tension in the room instantly skyrockets. The defendant and his attorney have agreed to this, likely hoping it will corroborate his story. But the judge's demeanor suggests she suspects the opposite. We're no longer just hearing the defendant's version of events. We are about to see it get fact-checked against the official record.
In drug court.
Let me just tell you, it takes more than that. So let me explain something to you. I am trying to decide whether or not to follow this agreement that's been reached with the state and the defense.
Mhm.
Now, I don't have to follow it because your contract is not with them, it's with the court. I could sentence you to 20 years. But I'm trying to figure out what's going on with you and why you were put out of felony drug court. And what I can tell you, because I've been an attorney in felony drug court, they do not put people out of the program because you relapsed.
See,
They do not put you out of the program because you're making bad choices here or there. What they try to do is they try to correct those issues. Now, if you disappeared on them, they only have so much time that they can allow you to be on a warrant and you've disappeared.
yeah.
So there has to have been something else going on other than you relapsed and you made some bad choices here or there. So why do you feel that they...
The email is here, and everything has changed. The judge's tone shifts from inquisitive to prosecutorial. Her question, what do you think the email that they just sent back me says, is dripping with drama? It's not a genuine question. It's a challenge. She already knows the answer, and she's giving the defendant one final chance to come clean before she confronts him with the truth. This is a masterclass in courtroom control. She knows the defendant's entire narrative is about to be dismantled, and she's laying the trap. She forwarded the email to the prosecutor, signaling that the proposed agreement is likely dead. The defendant's story of being a wronged victim is about to collide head-on with a very different reality, and we're about to watch it happen line by line.
put you out of the program?
You're probably not gonna, you.
No, I mean, at the end, let me just tell you, at the end,
My belief is because the district attorney changed from what the bailiffs in the courtroom and Judge Glenn's courtroom told me. She had only been there for a month.
Mhm.
So she wasn't able to actually see my progression throughout the process while I was in drug court for 8 months. I mean, I was at Lifetime for 3 of those months. I've been going to Judge Glenn's courtroom as required and going to my meetings with Elsa as required, going to my meetings with Tammy Banfield as required. And with the exception of two miscues, the last one being the close to the 30th there whenever I relapsed, and also showing up late to my probation officer.
Mhm.
Those were the few mistakes that I made. I mean,
Because usually they give you some options. They tell you, look,
I thought
we're going to try this last time, but we're going to do zero tolerance with you, or there's something else. So you're telling me this is all that's going on with them?
it baffled me as well. I was kind of speechless whenever I left there, and I wasn't on my medication because I just had gotten but from what I gathered, it all just seemed very confusing to me. I don't understand why they decided to. Because the last thing I heard from Elsa Guajardo,
Mhm.
she from meetings going to 2 times a month, she switched it to 1 day a month.
Mhm.
She said, because I've been doing so well.
The first bombshell from the email drops, and it's a direct contradiction of the defendant's story. The court says he absconded. This isn't a small detail, it's a legal term for abandoning his obligations without permission. He didn't just leave a sober living house, he ran away. Notice his immediate attempt to redefine the word and create wiggle room by asking, what exactly is abscond to run away from? He then shifts his story from an outright denial to a convoluted explanation that he was kicked out. But the judge sees right through it. She pins him down, exposing how he's trying to manipulate language to avoid accountability. This isn't just about a relapse anymore. This is about a fundamental breach of trust with the drug court program, and his credibility is now officially starting to crumble under the weight of the evidence.
And the same thing with Tammy Banfield. She gave me less meetings, group meetings than the other peers in my group because I was doing so well. She even called me one of her best students, and I was on page 7, or I was on the 7th step out of the 12 steps of the MRT book. And I even got housing at the VA residential housing at the GI Forum. And I was doing well, but all of it, that the one relapse, that did mess me up because I ended up losing my housing at the GI Forum, and which led me to going through the bank. I had tried so many places to get water, and then I had gotten sprayed in the face with mace because I was sleeping outside of a hospital because I got kicked out of the GI. Really, it's just I've been struggling with the addiction, with not having a job, which I
Shut up! Shut up!
attribute, the fact that I was able to get a job to drug court. Drug court did help me a lot, and Lifetime helped me a lot, which is kind of surprising why I was offered Lifetime again, which I would really like the opportunity to do that because I think they did well, especially Darnell over there at Lifetime Recovery. And they also helped me get my identification straight. They even got my driver's license back and all my IDs, and they put me in the door to housing. And it was just a great help to me. And I don't understand. I even saw you at the...
Now that his initial story has been proven false, the defendant shifts to a new tactic, feigned ignorance. He claims he can't remember things clearly because he was heavily medicated or not on his medication at all. This is a classic deflection strategy, an attempt to excuse his lies by claiming a lack of mental clarity, but the judge is 10 steps ahead of him. She uses this moment to deliver a powerful observation about the nature of addiction and deception. Her commentary that the stories people tell in the throes of addiction sound so true is a direct shot at the defendant's earlier performance. She knew from the start that his sob story felt hollow, and now she's explaining why. She's not just refuting his claims, she's deconstructing his entire methodology in front of him, showing that his attempts at manipulation are transparent and predictable.
graduation ceremony. It was nice seeing you there as well.
Shut up!
And I had gotten a job. I hadn't had a job in 2 years. I'd been unemployed, but I did end up getting a job just by looking at the bulletin board in drug court.
All right. So just one second.
Yeah.
Ms. Abrams, do you know why he was released from felony drug court?
Judge, it states on here, he had that new charge. It was a new offense on 5/1/2025,
Mhm.
and then on 5/14, he admitted relapsing. So you know that new number one automatic kind of brings it back to us.
All right, so it's the new number one and not just the relapse, because I know felony drug court would not put you out of program for a relapse, because sometimes,
Were you there?
oh, myself?
Mhm.
Oh, since the very beginning, since its inception. And I was there as a defense attorney
Yeah.
for that full time until I joined the DA's office.
Right.
Yeah, so years upon years
Mhm.
upon years.
Yeah.
Yeah. All right, so then if the state is taking care of the new number one, Ms. Abrams, can we see if felony drug court will accept him back?
Judge, I was actually pulled up program manager, but she doesn't want to be online.
Okay.
If you give me a moment.
All right, just have a seat. We're going to see. All right.
Thanks.
You're welcome.
Thank you, Judge.
You're welcome.
A few moments later.
Mr. Hawkins.
This is the checkmate moment. The judge calls out the defendant for moving the goalposts, and it's the most concise and devastating summary of his entire testimony. He started with a firm denial, "I never turned down residential treatment." When confronted with evidence, he shifted to a claim of confusion. "I don't understand all this legal things." The judge is highlighting his intellectual dishonesty. It's not that he doesn't understand, it's that he's changing his story every time he's cornered. She spells it out perfectly. Understanding a judge's direct order to go to residential treatment isn't complex legal things. It's a straightforward instruction. By exposing this pattern of deception, the judge dismantles any remaining shred of his credibility. He is no longer a confused victim. He is an active manipulator, and the judge sees him for exactly what he is.
What do you think the email that they just sent back me says?
You're in deep shit.
I mean, it's saying more than that. So what did you do? And here's the thing. Defense, I don't know if this agreement will work out. I forwarded to Ms. Abrams what they're saying. So the email that I have, what do you think the email is saying? Well, let's start with this. Did you abscond from the sober living house, yes or no?
No.
Oh, okay. Then we're going to need people here because it says Mr. Hawkins absconded and left the sober living house he was staying at.
What exactly is abscond? To run away from? I didn't.
You left and you did not return. Did you
They
leave?
kicked me out. They packed my bags and left them on the front hallway.
No, that's not what's saying here. And then,
Wait, okay, the sober living home, which one? Because I was at a sober living house.
well, let me ask you this. Did you ever leave a sober living home, a sober living house, and not return?
The one at 14823 Bending.
The judge lays her cards on the table, and it's a total rejection of the plea agreement. Her logic is ironclad. The proposed deal wants her to sentence him to residential treatment, but the email from drug court proves he was already offered that exact same opportunity, and he flatly refused. Why, she argues, would she order a plan that he has already demonstrated he will not follow? This exposes the defendant's entire strategy. He was trying to write his own plan, rejecting the strict immediate help from drug court in hopes of getting a more lenient path from her. He gambled that his story would be more convincing than the truth. The judge isn't just denying the agreement, she's punishing his attempt to game the system. She's making it clear that her courtroom is not a place for second chances you've already thrown away.
Point Drive, the one that I went
Now,
to.
my question is, did you ever leave? See, this is the problem. When people are in their drug addiction,
Out of options and backed into a corner, the defendant makes a last-ditch, desperate move. He tries to change the subject entirely by attacking the validity of his original charge. By By claiming the cop lied, he's attempting to relitigate a case that is long over. This is a classic red herring, a tactic to deflect from his current lies by dredging up old grievances. The judge shuts this down immediately and with surgical precision. She reminds him that that ship has sailed. He already entered a plea and the time to argue those facts is gone. She masterfully refocuses the hearing on the only thing that matters now, his pattern of deception in her courtroom today. She keeps bringing it back to the core issue. He lied about why he was kicked out of drug court, and now he is paying the price for that lie.
I was asked.
They want you to be very, if you're not specific with your words, then there's a lot of wiggle room. And I'm getting a lot of wiggle room from you. So let me just end it right here. They said that you left, absconded, you left the sober living home, you did not return. That's what they mean by absconded. You were not supposed to leave there and not return. You left and didn't return. Then they said you had this major relapse. Then after you had the major relapse, you pick up a new charge. Then they still don't want to kick you out because I've been in felony drug court and I knew they just wouldn't kick him out for a relapse or even leaving the sober living house, because sometimes that happens. Sometimes people don't do the program perfectly. That's why you're there. Then they said they offered you residential treatment and you refused to follow the plan set forth by the judge.
I'm speechless again. I mean,
No, I'm not, because that's what it says. I don't think Judge Glenn would be dishonest about saying that they offered you residential treatment and you turned it down.
I don't remember that. But then again, Your Honor, I wasn't on any medication when they questioned me.
And do you remember leaving the sober living home
That
and
part,
not returning
it
and
was,
then drinking yourself into oblivion?
it was the American GI Forum. I did go out without requesting to go out.
And you never returned.
That is correct.
The defendant launches into a long, rambling, and chaotic monologue to explain his criminal trespass charge. He details a story involving being maced by a security guard while sleeping outside a hospital, which led him to the bank to wash his eyes. While the story is dramatic, the judge knows it's a distraction from the main point. She expertly cuts through the noise and brings the focus back to the sequence of events that truly matters. He abandoned his sober living home, he relapsed, he picked up a new charge, and most critically, when the drug court still offered him a lifeline in the form of residential treatment, he refused it. This one act of defiance is the real reason he's here. The judge makes it clear that all the other drama is secondary to the fact that he was given a golden opportunity to get help, and he consciously chose to say no.
I came back the next day.
Mm.
And then when I came back, I stayed there for like 2 days and then they told me I had to leave.
No, they said you absconded, you left, you never returned.
The staff at the GI Forum told me I had to leave.
And then they offered you residential treatment and you declined.
They as in drug court?
Mm-hmm.
That part I don't
He refused to follow the plan set by the judge.
But then again, I forget things because I'm heavily medicated.
See, that is the thing. This is what I tell everybody. When people are in the throes of their addiction, the stories they tell sound so true. Like when he stands, I was doing great. I just had this one relapse. I don't understand what the issue is.
But
now we understand. Home. And even I've been in drug court before where people have left their sober living homes because they go back, they have a relapse, and then everybody's working, trying to get them back into compliance by trying to, probation officers go to their old hangouts. They even will, if somebody used to hang on a corner, they'll even go to that corner, ask people around, hey, have you seen this person? Because they are desperately trying to get that person back into compliance, back clean and sober, because that's what they want. So I knew that there had to be something else going on if it was just this one time. I was doing so great, then I relapsed. No. And then even though you absconded from the sober house, even though you relapsed.
The plea agreement is officially off the table. The judge has found the violation true and is moving directly to sentencing. The dynamic in the courtroom has completely shifted. The defendant's fate is no longer a matter of negotiation. It rests solely in the judge's hands. Now the attorneys for the prosecution and defense take on their final roles. The prosecutor, representing the state, recommends a sentence of 6 years in prison. The defense attorney, in a final plea for mercy, argues for the minimum sentence of 2 years, citing this as his client's first felony. The defendant, who walked in with a chance at avoiding prison, is now silently watching as the lawyers debate how many years of his life will be spent behind bars, all because his web of lies unraveled.
They still wanted to work with you and they wanted to put you in residential treatment. It was offered to you and they came up with a plan. What I do know is sometimes when people are in the throes of their addiction, they want to make their own plan. And I tell them, you can't make your own plan.
Your Honor, one way to make sure that this is accurate would be to just call GI Forum and ask them what happened. They would say they kicked me out.
No, I'm going to talk. Here's the thing. That whole thing about the sober living house, that whole thing about your relapsing, that's not even the big picture. You know why? Because felony drug court was still going to work with you. And they had set up a plan. They came up with a plan for you that involved residential treatment. And you said no.
I wasn't even on medication at that time when they questioned me with all these questions. I mean, I don't understand the law as well as y'all do.
See, so here's the thing. Now,
The sentence is in 4 years in the Texas Department of Corrections. This is a significant outcome. The judge didn't give him the minimum 2 years his lawyer asked for, but she also didn't go with the state's recommendation of 6, let alone the 20-year maximum. This 4-year sentence feels like a direct response to the defendant's conduct. It's punishment not just for the probation violation, but for his calculated dishonesty in her courtroom. She also requests that he be placed in the therapeutic community program in prison, a final, almost ironic gesture to get him the very help he refused when it could have kept him free. The defendant gambled that he could outsmart the system, and he lost. He didn't just get sentenced for his actions, he got sentenced for his lies.
now you're changing you're moving the goalposts. At first you're like, no, I never did it. I never turned down residential treatment. No residential treatment was never offered to me. And now we're on this kick where now you're saying, well, I don't understand all this legal things that are going on. The legal things that's going on when a judge tells you you absconded from the sober living house, you've relapsed, we're going to try to get you back in compliance by you're going to a residential treatment, and then you say, no, you're not following that plan. So, counsel, here's the court's issue. Felony drug court wanted him in inpatient treatment. He said no. There is nothing I can do for him. So if you all are coming before me and you all want me to follow this agreement you have where he goes into residential treatment, not going to happen because felony drug court has already offered him residential treatment and he said no. This is somebody who's writing his own plan and now they want to come to me because this is sort of like the end of the line where felony drug court, now they're really serious because now I'm before this judge and my only choice is to go to inpatient. I'm not going to follow that because he was given the option to go to inpatient treatment. He didn't want to.
You know what occurred during that meeting with Judge Glenn and Elsa Guajardo? I told her that the charge that I was initially in here for with Superior Court Judge Boyd was total bullshit. That the cop
So
lied.
here's the thing.
The cop lied.
Here's the thing. We're on the record. You are even going further afield of what we're here for. This whole thing, you were placed on probation out of this court in August. This whole thing that maybe this didn't happen, that ship has sailed because you entered a plea to it. You entered a plea of no contest. Stipulations were put in the record. I read them. I found that there was sufficient evidence to find you guilty, and I placed you on deferred.
Did you watch the video?
Here's the thing. You keep moving the goalposts. You said the only thing that happened to you in felony drug court was you relapsed and you were doing so great and you didn't understand why they kicked you out of the program. Now we have this email that your attorney said, yes, please email them and see what's going on. Now I have an email that says you absconded from the sober living facility. And then you come back at me, oh no, I just left for the day and I came back and my bags were packed. And then we come to the point that you abscond from the sober living facility, then you relapse. And then I say, that's not even the issue with felony drug court because that's happened to people in felony drug court before. They still try to work with you. So then here's the third thing. You do all of that in felony drug court, and felony drug court tells you, we will give you residential treatment. That's the plan. And you tell them no.
Okay, Your Honor. As far as the whole residential treatment, what you're referring to, the sober living facility, I stayed 1 month at a sober living house. That 1 month was up. The manager of the sober living house, he told me, you don't have a job right now, so you can't pay, so you get out. He packed up all my bags. I had to move. I moved into the American GI Forum. And around that date, April 30th, well, it was actually April 26th, I picked up and used. I used meth. I drank alcohol that night. I continued to do it for a couple of days. That night when I did pick up and use and I drank, I called the UA line that morning and they said, come into UA. When I did that, so at that point, I didn't make the UA. And then I went back to American GI Forum. And then at that point they said, well, they figured out, they seemed to have thought I was high on meth, or because I wasn't acting right, and then all that. So I just kept myself in my room. I was using meth in my room with American GIs. I'm not lying. And they put two and two together, and then they said, you're going to have to leave here. I had no other place to go. At that point, I went out and slept on the street, at the church, at the Christus Hospital. I slept outside the hospital. A security guard came, sprayed me with mace in my face. I was asleep. And then I walked to the frost bank to get water, to get it out of my eyes. Did that work? No, I got arrested. And that's where the criminal trustworthiness comes into play.
All right, so let's get to the point where, because according to the email, they say that you absconded and you left the sober living you were staying at. You know what? Let's assume that what you're telling me is the truth about that. Okay. They say the next thing you did was you drank yourself into oblivion and used meth and pick up a new charge. Okay. And this is what felony drug court is saying. Felony drug court's like, hey, he left the sober living home, did not return. You're saying you returned. Then he relapsed and he picked up a new charge. But you know what this email says? It says you left the sober living home, you relapsed, you picked up a new charge. Then after all of that, guess what felony drug court says? We don't want you out of program. We want to still work with you. And they come up with a plan. And that plan is for you to be in residential treatment, and you refuse to follow the plan. So this whole thing about you absconding from the sober living home, about your relapsing, about your picking up a new charge, that's not really the sole reason that you were released from felony drug court. The reason why you were expelled from felony drug court is because they had a plan for you, residential treatment, and you refused to go along with it. So now we're here, and what I can tell you is I'm not following this agreement because I can't help you. Drug court tried to help you with residential treatment, and you said no. So I'm going to find you guilty. I'm going to revoke. I'm taking in consideration 2025 CC 006392, give you credit for any time served. There's the therapeutic community. Is there any suggestion with regards to time? He's looking at 2 to 20 years.
Being familiar with the facts of the allegation. 4.
All right, the underlying facts of the allegation, you can review the stipulation. The court remembers those, but I'll give you the stipulation.
Slot.
And counsel, if you would like to review the stipulations as well, you can. Okay. All right. So what are you recommending?
6 years.
Defense, are you in agreement to 6 years?
No, Judge, we'd ask for the minimum. Judge, by the officer's own admission, he wasn't seriously injured. I think thank you. Judge, I think reasonable people can disagree as to the defendant's intent at the time of the offense. So bearing that in mind, And given the fact, Judge, that this is his first felony. Bearing all those into consideration, Judge, we'd ask for the minimum of 2 years.
All right, this is what the court will do. The court was, as previously stated, the court is finding number one true. The court will find you guilty, grant the motion. Take in consideration 2025 CC 006392. Give you credit for any time served. The court will request the therapeutic community. Doesn't increase the amount of time that you're in custody, but if you sign up for it and they accept it, it'll help you with your sobriety. And I'll sentence you to 4 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Didn't read it, no.
Okay. Did you sign it?
I did.
All right. Well, what that is that's telling you whether or not you have a right to appeal. You have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. You understand?
Limited as in what? I can't appeal?
No, you'll have to speak to your attorney. But what I can tell you is this. You entered a plea of true to violation of condition number 1. The court found it true. You are allowed to appeal that finding of true. All right. So that's your limited right to appeal. You don't have a right to appeal that, hey, I shouldn't have been on deferred adjudication for this because that time has elapsed. Do you understand?
So the incident with the police officer, I cannot appeal.
Yes, you need to speak to your attorney with that. I'm just talking to you about this specific process with regards to your motion to revoke. So with regards to your motion to revoke, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion in your plea of true. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. All right, good luck to you, sir. Thank you.
Thank you, Judge.
Oh, I'm sorry.
In the end, the defendant's carefully constructed house of cards collapsed under the weight of a single email. He walked in presenting himself as a victim of a harsh system, but the judge's sharp instincts and insistence on verifying his story exposed the truth. He wasn't a victim. He was the author of his own downfall. He absconded from sober living, relapsed, and then made the fatal error of refusing the very help designed to save him. The judge rejected his plea deal not just because he broke the rules, but because he tried to manipulate her court with a fabricated narrative. His 4-year prison sentence serves as a powerful reminder that in the pursuit of justice, the truth is not just a detail, it's everything. What did you think of the judge's decision to investigate his story? Let us know in the comments below, and subscribe for more in-depth courtroom breakdowns.